नमस्कार दोस्तों, मैं सीए मनमोहन जिंदल, एक्स बैंकर, retired from Canara Bank and registered valuer in security and financial assets, working from Mumbai. We shall discuss today bank's obligation to maintain secrecy of the accounts. We all know that bank is bound to maintain the secrecy of the customers and customers account. When a person opens an account in a bank, he is entitled to a reasonable assurance that information regarding the accounts remains a matter of knowledge only between the banker and the account holder. This is because it is one of the principal duties. It is one of the principal duties of the banker to maintain complete secrecy of the status of his customers. Even if your father has gone, your mother has gone, your brother has gone, bank is not bound to leak the information of your accounts. This obligation of the bank to maintain secrecy continues even after the customers close the account. If the banker makes an unwarranted disclosure of the status of account of his customers, he becomes liable to compensate the customer. So, my banker brothers should have the knowledge that you should not disclose the customer's information, or you will be rescued and you will be bound to pay the compensation. The bank's obligation of keeping the secrecy of the status of the customer's account is qualified and not absolute, because in some circumstances bank is entitled and required to make disclosures about a customer's account. What are the conditions where banker is justified in making the disclosure? First and foremost is under law. That is, without exception, you have to follow the law under express and implied consent of the customer. Sometimes it happens that a customer has applied for the CC, OD, or loan account, and he has to give the reference of another person, or give the request for the guarantee. Then, as per the request of the customer, bank share information to that person. Common courtesy among the bankers. Some bankers uh, in between or among the bankers needs some information about the customer in taking the best decisions of advancing him or not. Disclosure in bank's interest. If it is in the interest of the bank that information should be disclosed, then it may be disclosed. Disclosure in public and national interest. If the interest of public is affected by hiding the information, then bank is bound to disclose the information in the public interest. Number one, under law, a banker is justified to disclose any information about the customer's account when he is statutorily required to do so. Under these are the section Income Tax Act 1961, here section 131 and 133(6), Companies Act 1956 under section 235 and section 237, Bankers Book Evidence 1891, that is section 4, Reserve Bank of India Act 1937, section 26, and Foreign Exchange Management Act 1973, section 11, Gift Tax Act 1958 under section 36. We shall make another video on this section also for the better understanding and better information. Under express or implied consent of the customer. When an account is opened with the bank, there is an implied contract between the customer and the bank that the latter will not disclose information relating to his account without his consent. If, however, a customer permits his information can be disclosed. For example, the customer may permit giving information about his account to his prospective guarantor or customer. It is necessary to obtain the customer's consent before disclosing the information. The consent may be expressed or implied. Common courtesy among the bankers. Under the practices uses in banking system, it is customary among the bankers that whenever a bank makes inquiries with another bank, such as about proposed securities or acceptors, as information is shared. An implied consent of the customer is presumed to exist there. However, such information is kept confidential at both the ends and adequate precaution should be taken while furnishing such information. Disclosure in bank's interest. A banker can disclose information when it is essential to protect his own interest legally. For instance, there is a dispute between the customer and a banker regarding balance standing in the account of the customer. If there is a loan default, then bank will be justified in revealing the information to the guarantor, to a solicitor for initiating legal proceedings in the court of law. Disclosure in public or national interest. Bankers may be required to make disclosure in the interest of the nation and public at large. Public interest may be reckoned only according to the prevailing circumstances. So, bankers should adopt proper precautions while disclosing the financial status of his customer. Undue or irrelevant information can not only make the banker liable for compensation, but also the third party which makes use of such information may suffer loss thereby. It is therefore necessary to note the following points. Only facts should be revealed. Only such facts as are evident from the customer's account to be revealed. In other words, disclosure should be not based on rumors. So it should be a statement in general. The banker should give the information about the customer's financial position in general form. Terms commonly used and understood in the banking fraternity like ordinary, fair, good, excellent, and unsatisfactory in the ordinary course of business may be used for describing the means or credit of a customer. So he should not give in the plain words, but he should write that the account is ordinary, the account is fair, the account is good, the account is excellent, and if some sickness is there, then the account is unsatisfactory. Secrecy should be maintained by the recipient also. The banker should clearly state while giving the information that the recipient should maintain the absolute secrecy of the information furnished at his end. Number 4, disclosure of secrecy. It is the practice among the bankers to state while sharing information about customers with other bankers that the information was being furnished in strict secrecy and that the banker giving the information was not responsible and would not be liable for the information so given, and further that the recipient authority should also treat it as confidential. Information should not be given to person out of context or without proper justification. If a person who is not at all directly concerned with the customer of a bank asks information about the customer's account, the request of such person is out of context and hence the banker should not make disclosure. Suppose a friend has gone to the bank and ask the banker to reveal the information about his friend's account. So that is not required to be revealed by the bank, and he is not supposed to get that information. So thank you very much. This is on the secrecy of the information maintained to be maintained by the bank. For this is for information. This information is only for awareness purpose. Before taking any action, kindly go through the relevant guidelines. धन्यवाद.